A simple way of looking at it is it's a failing machinery.
Yes.
It's a failing system. I mean, for most people, there's certain kinds of things where you will get some sort of remedy.
Right.
But otherwise, it's a failing system. I mean, to say that I have to spend a huge amount of money to get a favorable court outcome. After that many years and having spent that much money, the question is what you're getting is a favorable verdict, but is it justice?
Yes.
At all. One of my party's agendas was liberalized prostitution.
Okay.
And I took this conversation across cities and into villages and rural areas.
Okay.
My experience has been 90 to 95% of men were opposed to the idea. कि क्या बात बदतमीजी टाइप का बात कर रहे हो आप? I am yet to encounter the first woman that opposes the idea. Not an urban woman, not a rural woman. For a woman, it's a non-issue. But I can assure you one thing. Every single woman in the city has been sexually harassed. She goes out to the market, she gets harassed.
Right.
Somebody looks at her in one way, somebody tries to touch her and brush past her or some. There is non-stop sexual harassment. There is not a single woman in Delhi who can claim that I have not been sexually harassed.
Right.
What we need is much better implementation of existing laws.
Yes.
Judges must move from being sovereign authorities to service providers.
So you talked about the concept of sovereign immunity which the judges have. You cannot practically hold them accountable for any wrong decision.
So the effective solution will be in terms of how do you deploy technology. All right, 50 years back we didn't have it, but today we have it. Na? Why don't you think differently?
Hello and welcome once again to Kitabi Baatein, a podcast where we make sense of India and the world through books. In today's show, we'll talk about law, judiciary, India's legal system, and the elusive justice. We all know that after 77 years of India's independence, India has many victories, many achievements to its credit. However, when we talk of providing legal services, providing justice to a common man, unfortunately, we cannot count that as an achievement, as justice is still elusive for a large chunk of our population. Who is responsible for this? What is the problem with our law and order machinery? What's the problem with our judicial system? To discuss this, I have a very special person as my guest today, a lawyer with more than 3 decades of experience, the one who co-founded Trilegal and is now the founder of law firm AP & Partner. Mr. Anand Prasad, welcome to Kitabi Baatein.
Thank you, Abhishek. Happy to be here.
How are you?
I'm very well, thank you.
So we'll discuss about Mr. Prasad's book, Unshackling the Elephant. And I'll tell you, this is one of the books and wherein you want to learn about law, how it is elusive for the people, what exactly is the problem with judiciary, with the problem with say, lawyers, the entire law machinery. This is a book you must be reading because it's written with a layman's perspective. If you don't know law, just like me, you'll get to know many things which are wrong with our legal system and judicial system today. So congratulations on the book. I must say it's an extremely well-written book.
Thank you.
Your book raises many important points, asks many difficult questions, and interestingly, it also provides answers to those. So if we start with, as I mentioned at the very outset, that justice is still elusive, even after 77 years of independence, it's elusive for a very large chunk of population. Either you need to have a lot of money or power or connections, or both if you want to get justice in India. How do you see this entire judicial machinery in India right now?
A simple way of looking at it is it's a failing machinery.
Yes.
It's a failing system. I mean, for most people, there's certain kinds of things where you will get some sort of remedy.
Right.
But otherwise, it's a failing system. I mean, to say that I have to spend a huge amount of money to get a favorable court outcome. After that many years and having spent that much money, the question is what you're getting is a favorable verdict, but is it justice?
Yes.
At all. And for lots of them, even that outcome is not visible.
Right.
So really the question is how should we look to fix some of this stuff? My book principally comes, so while it's a book on legal reform, but it's sort of looking at, it takes a few ideas and then works with them. One is that we are a country with a lot of regulation and a lot of laws.
Correct.
And what we don't need is one more law.
Right.
And I'll give you an example for what I mean. What we need is much better implementation of existing laws.
Yes.
So you have, let's say, you have there was this Nirbhaya case that happened. And then suddenly everybody woke up. Rather than figuring out how do you convict somebody at a great speed, we went into how should you make a 7-year or a 10-year punishment into lifetime, whether that person should be given death sentence or not. And my point is that यार तुम 7 साल के लिए तो किसी को जेल नहीं भेज पा रहे हो.
Right.
I mean, if you have to avoid death sentence, just if you look at criminal justice system, it's a challenge to give somebody death. It's a steeper hill to climb in terms of evidentiary value. You can't do the easy one, which is the 7-year death sentence. So you have one and done, you want death sentence or you want life imprisonment. Now, this approach, what it does is, because that's what happened, the law became harder.
Yes.
But what did it deliver at the end? Have there been a reduction in crime against women? None. So what did you do? Public sentiment got assuaged at that time because you took the easy path. Easy path is कि parliament में एक legislation डाल दो, तो public सब खुश है कि अब death sentence हो गया. आज तक किसी को life imprisonment नहीं मिला, right, for something as heinous as that. And that you will find is an approach to many things. I mean, when I look at, let's say, sexual harassment at workplace, now it requires there was one Supreme Court judgment that sort of laid down, all right, this is the kind of rules, etc. And we look to follow somewhat the US system. But the fact is that in the criminal justice system, when you do acts of sexual harassment, almost every act of sexual harassment is an offense. Correct. There are some acts that are not an offense, but so for example, if I every week show up and ask a girl to have dinner with me, it's not an offense until that innocuous thing starts hassling her. Right. Then it could get into the territory of an offense. Now, what we have done is every other thing, when there is physical touch or you there is any of those egregious forms, it is an offense under the old IPC. You can actually get a conviction. When you don't get a conviction over there, because your process is failing, what you do is you now create a new law. The good thing about the law is it has created a slightly separate process in terms of sexual harassment, in terms of how a company will become liable, what sort of mechanisms must exist, etc. So it's become easier to get there. Right. So that's the good thing. But I would say therefore you've created a new process. If your existing process was effective, you could have just put that person through that process and you would have gotten an outcome. Correct. So our reactions very often demonstrate that we don't have confidence in our existing legal existing laws. And the confidence is not there because we are incapable of enforcing. You make a new law. In the early days, I can assure you that look as if this is now working well. Give it a few years, it will stop working. Because people will figure out a way out to sort of circumvent it, and you'll find it happening even when it comes to sexual harassment law. So, what we need is a greater focus on enforcement. How do you make sure that the system works? We don't need more statutes. We don't need more books. We just need effective enforcement of the law. At a quick pace. Right. And essentially my book, that's the challenge that my book looks at. And it comes up with a few solutions to something like that.
So delving deep in your book, you spend a lot of pages in this book about Supreme Court. And you mentioned about one of the problems is the collegium system of selection of judges. And as a layman, I've been hearing about in newspapers that this system is flawed. An attempt was made in 2014 when the NJAC bill was introduced. Now, under collegium system, what's happening is that judges recommend judges. So there's there's always a likelihood there with nepotism, there will be favoritism, and we may not be having the right person for the job. What do you think is the solution? And given that already Supreme Court did not allow the NJAC to succeed, how you think we can implement something better in the future?
So let me not get into criticism of the collegium system. All that I will say is almost everybody knows, including the judges that support it, say that we know that there are problems with the collegium system. Their sense is that, but there is nothing better.
Right.
The old system was flawed. That's why we went to collegium.
Right.
We know that the collegium is not working, but there is no other way. So nobody seems to have a way to do this. So I have a very different approach to something like this. I have got an approach that sort of is more US styled in that sense.
Okay.
So it's not the executive that sort of appoints judges, which
Right.
is the old system, with some degree of participation from the courts. It is now, how do you get those nominations reviewed and approved by a parliamentary committee? So it's very US styled thing. The pushback to that is, yeah, how can we trust our parliamentarians? They're completely useless, etc. I mean, why will you give them authority?
Yeah.
And my limited sort of approach to this is that first, ask yourself, do you like the idea of democracy? And in democracy, do you like the idea of universal adult franchise? What I mean by that term, either the rickshaw wala across or the chai wala has the same vote as you have.
Yes.
You may think that I'm much better educated, etc., but electorally, both of us have the same power.
Same power. Correct.
So what we are doing is we are telling all those poor guys over there that you have the same. We said this 75 years back, or whenever we became a republic in 1950. Now what we do is we try and subvert their power.
Yeah.
Because they, with whatever little wisdom they, either you don't like universal adult franchise, but once you give it, you now actually subvert their wisdom. So they, with whatever limitations they have, elect some people to parliament. That is what you told them. That is the romantic idea that you sold to them. Now what you say is, those guys who come elected, because those bunch of people illiterate, or they are not good enough, they don't have brains. So they have gone on caste, religion, money, whatever basis, they have gone and elected somebody.
Right.
What did you think when you give a universal adult franchise? How did you think those people will behave electorally? Did you expect them to behave any differently?
Right.
If you thought they would behave any differently, that reflects your stupidity.
Correct.
But now what you're doing is, rather than address that as a situation, what you have said is, let them function in the disbelief that they have an equal say.
Yeah.
I, as the elite, will subvert that mandate. So therefore, you may have set up people's representatives, but I will not subject, as the elite, I will not subject myself to review by the people's representatives.
Right.
So therefore, what you are doing is you're subverting that. Now, I do believe that our parliamentarians do have a problem, but that is the system that we have picked. That is the system that we back. Even today, there are very few people who will say that the rickshawala's right to vote should go away, or the panwala's right to vote should go away.
Right.
As long as you are given them the right, why should you have a superior right to control what happens at the judiciary over them?
Right.
So that is the first level of argument that I'll say when you think it of the executive doing it, because it's not going to parliamentary review.
Yeah.
I would say that your judge's appointment must be subject to review of the people. Whichever way they go.
Right.
They appoint terrible judges. I agree that terrible judges is a bad thing, but the idea of democracy is you learn through bad decisions.
Correct.
You can't expect a democracy to deliver perfect decisions at all times. And there's an entire report that all our judges must be supermen or superwomen, and they are capable, they are sort of outstanding rock stars, is a flawed idea when you talk in terms of democratic setup that you have given for yourself, because that doesn't allow the people's representatives to learn from their mistakes. So once you appoint a terrible judge, you also learn what happens when you appoint a terrible judge.
Yes, correct.
And you then allow for the people to educate yourself. This is the entire essence of democracy. And being sort of a classical liberal, I am very much for people's rights and people's freedom.
Yes.
So my sense has always been that you give that authority back to the people.
Right.
It is a mandate of the people that must review and allow for judges.
Right.
And once they're appointed, you appoint them for lifetime.
Right.
But the judges should not, as they are today, be unaccountable. So
Right.
the lack of accountability must also go away.
Right.
So you make judges accountable in terms of performance reviews. Now, I have a few ideas over there what it might mean by performance reviews, but they have to be functional performance reviews that are out transparently.
Right.
Judges must move from being sovereign authorities to service providers.
So you talked about the concept of sovereign immunity, which the judges have. You cannot practically hold them accountable for any wrong decision. If they
So it's same sovereign immunity exists for government officials also. Because my book is on legal reform, I say it in the context of judges. But the fact is, and when I raised this, that you should not have sovereign immunity, so sovereign immunity and must go away, or it must get limited in any case in a great deal, and you must have performance review. So you have people appointment, lifetime tenure, subject to performance review, and reduce sovereign immunity. What I mean by this is, you and I as professionals functioning in the private sphere, do we have sovereign immunity? No.
No.
Are we able to function well? Yes. Do we have clients that we advise? Yes. If we give wrong advice, even with the best of intent, we give wrong advice, is the client entitled to come after us? The answer is yes.
Yes.
Why should there be a special category of people where they are clients or they are customers? You are rendering a service. Why should you be entitled to say you can't come after me?
Right.
Now, if this means that their remuneration must go up, so be it. Give them higher remuneration. But you must have accountable judiciary, and therefore accountability must connect back to the people. It must come from the people, it must go back to the people.
Very true.
So that's the entire sort of architecture.
So 2 points you mentioned related. One is related to judges about a lifetime judge, because you said during the time of retirement, they may be more concerned with what they will be doing post-retirement, and some of their decisions may actually reflect that. That's typically what happens with bureaucrats as well, that they look for opportunities after retirement. But do you think if you give them a lifetime kind of job, they may become accustomed to the idea that we are here for the long term, and it doesn't really matter because we anyway enjoy sovereign immunity? So don't you think that will not be acting as a deterrent? Because if they know कि हमें तो कोई कुछ कर नहीं सकता, पहले तो मेरे 60 पे रिटायर होना था, अब तो मेरा कोई एज ही नहीं है. Don't you think that was
62 and 65.
65, yeah, sir. But don't you think it may be a bit counterproductive?
So, which is why I said the entire architecture is one of performance review, etc.
Right.
So, with the existing system, if you just shift the needle only on tenure, see, think of it also slightly differently, is that one of the ways that we have framed our system, and this is framed in the mid of the previous century. People thought differently. Society was different in those days, and life expectancy was different. At the age of 58 and 60, people are old.
Yeah.
I am closing into 60. I feel that I'm a teenager.
Yeah.
So life expectancy and your health conditions have improved. You look at a lot of our judges that are retiring now, they are good to go for another 20 years.
Yeah.
So it makes no sense to sort of continue to foist a 65-year sort of or 62-year compulsory superannuation on judges, and therefore it must go up. Now, one of the things that I say is that provided that you do have accountability and you do have review mechanism, like I'm saying, is that if you have either an extended tenure, so either you make the 60 as 85 or something like that, or you give them life tenure. The US has life tenure because the constitutional value is you shall not discriminate on the basis of age. It's a complete non-discriminate sort of legal society, or system at least.
Yeah.
Even if society has discrimination, all societies have discrimination of one kind or the other. The legal system therefore says you shall not discriminate on the basis of society. Now, on the basis of age, sorry. So, if you just shift the needle only on age, with everything else remaining the same, what is likely to happen is, even today, till the age of 62 or 65, a judge who is lazy will continue to be lazy. A judge who is a performing judge or an average judge will continue to perform the way they are. What does the life tenure actually do? The life tenure actually gives you some degree of certainty of continuity as a professional. So, you have been a judge, you now feel that today, if I am supposed to retire at 60, let's say I am a High Court judge, which for me will be another 2.5 years, I'll be actually worried that what am I going to do now? Now I'll have to become a senior counsel again, pick up from scratch and start building a legal practice.
Right.
Lots of judges are not able to do it. So it's a different profession. So what you start doing, you start maneuvering. It's human nature. We think our system is devised on the basis that our judges are superhuman beings.
Yes.
That they are the epitome of everything that is good, and we somehow fail to recognize that everybody is a human.
Right.
And we have human failings. The best of us will have human failings.
Correct.
Our religious traditions tell us that there is nobody who's completely good or nobody who's completely bad at all times. If you look at our devas and you look at our asuras, and you'll have all shades of dark and white in all of those. The same characteristic is reflected. So you can't operate on the basis that, oh, these two judges out of the last 200 and the last 20 years were like this, so everybody else must be like that. It is absurd to have that approach.
But that's more of a colonial construct, isn't it? It's derived from the colonial laws treating judges some sort of superhuman.
So it is in that sense. When you say colonial, think of it like this, is that our entire legal system is basically, our governance system, our democracy is set up on that basis.
Right.
So I would not put it back to colonial. I mean, we have also have 75 years of independence. We are happily sort of living like that.
Right.
So I would not blame colonial ideas because they worked well in the period that they were set up. The question is, should you be revisiting it or not?
And updating as...
Should you be updating or not? This whole idea that वो इतना 75 साल से चल रहा है तो मैं अभी भी ऐसे ही रहूंगा is absurd because you now respond to the new reality. You look at कि अभी क्या काम कर रहा है, क्या नहीं कर रहा है. You make changes, you make improvements. We don't seem to have that courage.
Right.
Our courage seems to be very precedent based कि नहीं पुराने से ऐसे चल रहा है, मैं नहीं चेंज करूंगा. इसको चेंज करने से मेरे को बोनस थोड़ी मिलता है. और अगर गलत हो गया तो मेरे को और जूते पड़ेंगे. So that's the mindset which sort of drives our governance thinking of the state.
Right.
Which is where the sort of the performance incentive must be brought in. Right. Not just in, I mean, my book is not about bureaucratic reforms, but there is no reason why there should be no performance linkage.
Of course. So we talked about judges. Another question from the point of view of a common man is what one can do about lawyers. If a lawyer is engaging in anything illegal or his lawyer is not supportive of his or her client, what is the recourse for a common man? What can a man do?
See, the best answer to many of these things is transparency. So like this, sunlight is the best disinfectant.
Yeah.
Now, if you look at, let's say I ask you to find a lawyer. Let's say you are in the consulting business and you deal with lawyers, so you will know some lawyers.
Right.
But let's say I ask your colleague, he's got a problem, find a lawyer. He's now in a strange world because he doesn't know who to pick. So he goes to his friends, he tries and find out kaun vakil milega, sort of thing. So it is very opaque.
Yeah.
You land up with whoever you land up. And that lawyer then becomes your god.
Right.
For that particular instance. And therefore, whatever that god does until the time you get hammered very, very bad. Very often you're getting hammered, you don't know.
Right.
You think that everything is going well.
वो ठीक ही कर रहा होगा.
वो ठीक ही कर रहा है.
Right.
So the opacity is the big problem when it comes to lawyering as service. If you make it transparent, so you allow for lawyers to sort of be out in the open. So this is where we continue with the old colonial system of sort of lawyers should not be doing marketing and should not be putting out their services, etc. With every other, why should lawyers be treated differently from, say, let's say, a management consultant?
Right.
So ultimately, we are offering a service to the people. People must be able to find me easily.
Right.
You can't create a situation where people are struggling to find their service provider. Therefore, I must have a mechanism to also figure out which are the better service providers and which are the inferior service providers. I must have the ability to say कि अच्छी है ज़्यादा पैसे charge कर रहा है, तो should I pay him or not? So some sort of transparency in terms of how track records are measured and how they are in the public domain. Right. So that is what that kind of transparency is what will bring cure to.
Right.
The common man's ability to pick lawyers. Right. Now, lawyers obviously will not be, lots of lawyers will not like the idea. But I think the existing system, which is sort of, it is self-serving in the sense that it is undermining the very reason why the profession exists.
Yes.
And there'll come a point in time where there'll be loss of confidence in the profession, and it's not very far away. And if there's loss of confidence in the profession, then all lawyers will suffer.
Correct.
So you need to do a fix where confidence comes back in the legal profession. I mean, there were some years back when I started off as a lawyer, people say कि तुम्हारी तो शादी नहीं हो पाएगी, कोई वकीलों को अपनी बेटी नहीं देता, शादी कर लिया. Now that is because that is showing you the slide in the standing of a lawyer.
Right.
Whereas at one time, if you look at it in the West, see where the legal system is functional. Lawyers are highly marriageable.
Yes.
Sort of, you are high in that bracket. So it's one dipstick. I'm not making a joke out of it, but that's one sense for how do you get social acceptability of a certain profession. In our cultural context, we think of it in terms of अपनी बेटी किससे शादी कैसे करते हैं क्या नहीं.
It's very true. So, Supreme Court, I have one more question, which is that we of course criticize that this is wrong and that is wrong. But one thing is, as you mentioned in the book, Supreme Court is overburdened. The idea of a Supreme Court in any country is primarily related to the interpretation of, say, the constitution or the key laws. And yet in India, it's overburdened with many things which the court should not be doing. For example, PIL, as you mentioned, that PIL has become a tool in the hands of everyone that whatever you feel is wrong, you can just, through a lawyer, you can get a PIL drafted. But the court is wasting a lot of precious time, which it should ideally be spending on other things. How do you see that and what's the remedy?
See, one of the things that I should say right off the bat is most of our judges, when I say most, I'm talking in excess of 95% of our judges are very, very hardworking.
Right.
They are some of the hardest working professionals in the country. They are grossly underpaid. And you put so much burden on them that they begin to crack.
Yeah.
So if you burden any of us, I mean, both of us are professionals. If there is too much work, we'll basically crack under that. Then we'll find, psychologically, we'll find ways of doing other things.
Right.
That are lighter, which sort of takes me away from the reality of having to do what I'm supposed to do.
Right.
There is too much burden, there is too little pay. It is not, and which is why I say, even when I say performance evaluation of judges, that there must be remuneration that is taken a look at once again.
Yeah.
So Singapore style, where you sort of pay much higher
To judges.
levels to judges.
Right.
That's one part of it. The other part in which you were alluding to is what do you do with, so there are two questions over there. So they are sort of mixed up. One is the case volume.
Yeah.
And what should we do with case volume? And my answer to that is not, if you see, I do not once suggest double the number of judges. See, when you're talking about increase the number of judges, one of the issues that we do not recognize is do you have the volume of people that will become judges? So it is absurd to say कि judges को बढ़ा दो, double कर दो, triple कर दो. Second, almost all of us have lots of situations where we deal with unfairness, where we don't go to court or we don't go to the law because we think it's a waste of time.
Waste of time.
मतलब there's too much effort, too little return.
केस चलता रहेगा.
केस चलता, मतलब जो भी है पैसे खर्चा होंगे, it's a pain, so you just swallow the injustice.
Right.
Now, look at what happens when you have a highly successful legal system. All those issues, we will take it to court, which means the volume will go up again. So, if any thinking that revolves only around the fact that you will increase the number of judges and you will solve the problem, first of all, you're being foolish because you think that only the workload that you're getting today is the only workload that you will get. And therefore, you need more service providers. Let's say that you sort of have 10 times more judges. I mean, that is the kind of volume of judges that you will need. If you've got 300 years of backlog, then that's the kind of volume of judges that you will need. And that volume will go up,
of course,
of cases. So this, I don't think, is an effective tool. So the effective solution will be in terms of how do you deploy technology. All right, 50 years back we didn't have it, but today we have it. Why don't you think differently? You have, when I say technology, I am talking from elementary and basic technology to slightly more complex technology. So elementary and basic is of live streaming kara do, online courts kar do, improve the quality of screens and cameras and voice systems so that you get not as if you're in the same room, but you get 80% of the impact as if you're in the same room. You also, there are many other benefits to it, but you do that. It's also technology. You have a know-how system and a training system for judges. That's also how do you deploy technology. And you can use AI in various measures.
Correct.
Ultimately, your real answer will be when you can have AI judges.
Right.
So AI in the early stages will be how do you use translate. तो मैं तेलुगु में बात कर रहा हूँ and आप हिंदी में बात कर रहे हो, तो both of us on the same footing.
On the same.
Today our legal system is कि अगर मेरी अंग्रेजी ज्यादा अच्छी है तो and आपकी कमजोर है, then you are actually at a disadvantage on day one.
Very true.
Now, how do you neutralize this language arbitrage? So, technology can neutralize this language arbitrage. Is that a wealthy person or a wealthy business can hire some of the best lawyers? One of the things about best lawyers is their language skills are great.
Very great, of course.
Whether it is writing or it is speaking.
Right.
One of the things about a poor person is that the lawyer that they hire language skills are lower. And that is where you basically, it's a system designed for that sort of arbitrage. To work for the wealthy and not work for the. I'm not talking about the wealthy's ability to bribe, etc. Just assume all that is not there. वो है, लेकिन assume कि वो सब नहीं है. Still, you will find that the system by its design. Now, in the 18th century, when the English designed the system, there was no other option. ऐसे ही था.
ऐसे ही था, right.
ये इस और ऑप्शन नहीं था. 1950s में भी जब हमने ये सिस्टम को कंटिन्यू किया तो कोई और ऑप्शन नहीं था, यही था. And until 20 years back, there was no other solution than increase the number of judges, increase the number of courts, physical infrastructure, expand कर दो ये वो. उस टाइम ये सब टेक्नोलॉजी मेजर्स नहीं थे. आज के दिन हमारे पास कनेक्टिविटी आ गई है. आज के दिन हमारे पास हाई बैंडविड्थ आ गया है. आज के दिन हमारे पास बड़े कंप्यूटर टेक्नोलॉजी एंड बीपीओ सिस्टम्स एंड ऑल जो जैसे काम करते हैं वो आ गया है. एआई अभी बढ़ते चले जा रहा है. डिफरेंट काइंड्स ऑफ एआई इज अ जेनेरिक टर्म फॉर मेनी डिफरेंट थिंग्स. So you are using algorithms. I prefer to use the term algorithm over AI. But there are algorithms that you can put together to deliver on various aspects of the justice system. What you are doing is you are taking the burden of human beings and you're transferring it to an algorithm. Now, the way that will work, and to deal with your question on volume, is that we have hundreds and thousands of landlord-tenant cases.
Yeah.
For the last 100 years, हमारे यहाँ landlord-tenant cases चल रहे हैं. Can you ever imagine that there will be a new variation to a dispute between a landlord-tenant that has not happened before? तो all you need to do is कि पुराना जो जितना डेटा है उस सबको करके डिजाइन करो, एक एल्गोरिथम डिजाइन कर लो. उसमें all variations will fit in,
right,
one way or the other. Similarly, an employer-employee dispute,
right,
labor disputes, every sort of variation is already
there, right.
You can easily take off a whole load of volume from the human beings and put it in the realm of technology.
Right.
Initially, you can have that technology supporting the human judges. So, what a judge has to physically do, there's technology that does it for him and gives him some work product, and then he sort of cleans it up and he signs off on it. So, तुमको एक ready-made, it's like a court clerk.
Right.
So, you've got instead of a human being, you've got an algorithm that works for you. It improves the speed at which you deliver. I mean, as a lawyer, I know this. So, if I have to draft a contract, you start from scratch, it'll take me 4 or 5 days to do it. I use a know-how system within 3 hours and generate a complex document.
Right.
Why can't
the
courts do it? I mean, as consultants and advisors and commercial lawyers, we are doing it regularly.
Right.
There's no reason why judges should not be able to do it. Just imagine the amount of workload you'll be able to do in the same amount of time.
So the court needs to upgrade.
अच्छा, इसमें ये भी सोचो, HR cost मेरा कम हो गया because I don't have to spend more. I don't have to build physical courts.
Right.
उसमें पैसा लगता है. Technology सस्ते में बनता है.
Right.
So it's easier and cheaper solution. It's a more outcome oriented one. When you come to the PILs, see, the PILs are a different question from volume. I mean, the fact is that PILs create, because the volume, PILs become more of an eyesore than they should be.
Yes.
क्योंकि मुझे लगता है कि मेरा लैंडलॉर्ड टेनेंट केस है, तुम सुन नहीं रहे हो और तुमको इंडियन क्रिकेट की टीम कैसे चलनी चाहिए वो उसमें ज्यादा इंटरेस्ट है, और मेरा क्या जो टेनेंट वहां से निकल नहीं रहा है 20 साल से. सो यू फील एज अ लिटिगेंट, यू फील दैट आई एम गेटिंग स्क्रूड ट्वाइस ओवर बिकॉज ऑफ दिस PIL thing. But you look at also Why do PILs have that? PILs also started in the Indian system in the 1980s. Since then, we have had a greater level of governance failure. Now, the answer to governance failure in the traditional sort of democratic mechanism has been somebody is not governing well, you vote them out, you vote somebody new in.
Correct.
But these days, the multifaceted things that a state does, there's no 1, 2, or 3 things on the basis of which you vote, and ultimately what you vote for is something altogether different.
Right.
So it is not a solution for your regular problems. There is no way. I mean, you make a representation to the government that goes into a black hole. उसको पता ही नहीं चलता कि वो डस्टबिन में चला गया कि कोई फाइल में बंद करके लगा और somebody is applying themselves to it. So PILs are basically the court's reaction to this failure in governance. Now think in terms of a judge. Judges are human beings. I am also suffering the same issue that you guys are suffering as common people. I also know कि जब मैं जज नहीं था तो कैसे धक्के खाना पड़ता था गवर्नमेंट को. आज मुझे लगता है कि मेरे पास पावर है. Why don't I actually exercise it and deliver something that is good? In its intent, it is well-meaning. Because here, the judiciary is trying to fix things that governance is not doing, and governance is opaque.
Right.
It does not react to it. Like pollution dekho Delhi mein. Why do you think courts are getting involved?
Right.
It's not as a solution, but there is frustration. कि कोई कुछ कर नहीं रहा है, कोई कुछ बोल नहीं रहा है. It doesn't seem like there is any serious. There is no point in सरकार चुपचाप अपने in closed doors serious meetings कर रही है. There is no transparency. You're supposed to sort of. So what happens is that opacity results in somebody going to the court and a judge taking cognizance of a PIL, and then he gets involved. Now the problem is that a judge is trained as a lawyer. He's trained in law. He's not trained in governance. He's not trained in administration. That's not our basic training. Coincidentally, one of us might turn out to be a good administrator, but otherwise we are not trained as management people. We are not trained as administrative people. So I start now because of my frustration, as a judge, I start passing orders. So these orders are not informed by things that managers and administrators should typically be informed with. When you take a business decision or when you take a governance decision, there is popular sentiment that you understand, you sort of deal with it, you take people's feedback, etc. In a PIL, there is no feedback.
No feedback.
एक आदमी कुछ बोल रहा है उसके बेसिस में whether I agree or not and my own personal gut feel, I pass an order. That order may end up hurting the sentiment of a whole host of other people. But they have no, if the same decision was to be taken by a state, by the government, they will take into account other people's sentiment also. Okay. There'll be a more balanced decision. The problem of failure in governance is there is no decision making. People are interested more in how do I win the next election, less in governance.
Very true.
So that's where courts get involved. Okay. Now the problem with that is a constitutional scheme, and this is where, so I'm describing the human element of PILs. The problem in the context of constitutional scheme is separation of judiciary and executive. So the scheme is that the executive will take everything into account and it will take some action or it will not take some action. A court will review that action to see whether it meets constitutional norms. The remit is to review.
Right.
Now what happens is when the court takes a decision, there is nobody to review. And it becomes binding on a whole host of people whose sentiments have not been taken into account. Right. So when you do excessive PILs, it's like हींग. दाल में थोड़ी सी हींग हो उसमें मजा आता है. बहुत ज्यादा हींग हो दाल खाई नहीं जाती.
Correct.
What we are faced with is दाल में बहुत ज्यादा हींग.
Yeah, right.
And there is lot of the decision making is not working on the ground. So it is failing. When it doesn't work, it undermines the judicial authority. Right. Because it's not working. People are not following it.
Right.
सबरीवाला में तुमने जो भी बोल दिया लोग ने कहा कि नहीं ऐसे ही होगा.
ऐसा ही हो.
So it's not working. You're not capable of giving effect to it. So don't put yourself in those administrative situations. Confine yourself to the review mechanism. My suggestion is that you have these transparent, open public fora where people can go and file PILs
Right.
before this tribunal. Tribunal can be manned by judges, senior lawyers, people who have got a professional obligation. So these are not ad hoc कि एक hearing के लिए मैं चला गया और उसके बाद मैं वकील बन गया.
Right.
So it's a sort of long tenure. So it's a tenure appointment.
Correct.
I've not given thought to whether it should be a 5-year tenure, it should be a 65 years or a life tenure. But a tenure appointment where somebody can take their job as a serious professional.
Right.
And you're looking to build a career. That's your career. So you will now carry the burden of actually delivering as good as you can.
Right.
Now, this decision making will then get subject to judicial review.
Right.
So where there is failure of governance, you go to this tribunal and then that gets subject to judicial review. Therefore, judges go back to being reviewers of
Right.
executive decisions. And this should be treated as an executive decision or a quasi-judicial decision.
So, two of the things you talked about in the book, one is common law and civil law, and you emphasized a lot in here to follow the civil law process, not common law, which is currently there. So, from a layman's perspective, you have to explain common law जो हम follow कर रहे हैं अभी क्या है, and how does civil law helps in your improvement of the overall law, and how does it do it?
So by and law, एक थोड़ा मैं मतलब I'll take a couple of steps. There's some history involved. So common law is basically an English principle. दुनिया में England, the US, Australia, Malaysia, Singapore. So they are India, Pakistan, Bangladesh. These are जहाँ British Raj था वहाँ पे you got a system called common law that works. Now common law has certain features to it. Europe, that is continental Europe, China, Japan, all these follow civil law. अब इसमें फर्क क्या है? So I look at the thinking is why should there be a change? Why not common law में क्या फर्क है? So common law, when you ask most people, will tell you कि it is precedent oriented. Precedent oriented मतलब सेम डिस्प्यूट पहले किसी ने ऐसा डिसीजन लिया है, मैं उससे ना भी एग्री करूं लेकिन मैं भी वही डिसीजन फॉलो करूंगा
बिकॉज पहला ऐसा हुआ है.
Similar things happen in governance when it comes to state action. Similar things happen in judiciary. Judiciary is built into a constitution that you have to follow the superior court. So basically you follow what has happened in the past. And that's called precedent. Is this whole thing of following पहले किसी ने किया तो मैं भी वही करूंगा. Now मैं भी वही करूंगा is not an abdication of thought process. It is even if I disagree with पहले का decision, I will still have to follow that पहले का decision. The only alternate is to overrule, which means that I have to either be a higher court or I have to be a bigger bench in the judicial. When I say bigger bench, means more judges to overrule. So there is no freedom to do what I think is just. I have to follow what that guy said in his facts, what is just. So what we are faced with is judges that in criminal cases, etc., you'll find that, and it's more stark in criminal cases, you also see it in a lot of civil and commercial cases. A judge will say, I think that this accused is guilty, but I am unable to convict him.
क्योंकि प्रेसिडेंट नहीं है,
क्योंकि मेरे पे वो अथॉरिटी नहीं है एंड ही इज इनोसेंट अंटिल प्रूवन गिल्टी. तो तुमने यू आर फेल्ड इन प्रूविंग गिल्टी, तो मेरे को उसको छोड़ने में. सो यू विल फाइंड जजमेंट्स लाइक दैट. You will also find judgments which say that I agree that I will want to do something else, but my hands are tied because of that precedent. So they are recorded orders that say things like this. So you see it quite. Then what has happened is, because the level of frustration has grown, our judges are not. It's very frustrating to sort of deal with something and say that तुम कुछ नहीं कर सकते because somebody has said something earlier.
Right.
So what you do is two kinds of features have culturally have started building into our judicial functioning. One is I just ignore the earlier case law. अगर किसी ने साइट भी किया हो, मैं उसको मतलब अपने जजमेंट में एनालिसिस में लेता ही नहीं हूँ, अपना ही एक कहानी कर देता हूँ. So as a result, what happens is there are two judgments now in conflict. So this sort of situation is increasing. You'll see Supreme Court will say that different benches should not pass different orders in similar cases. So अब वो news में भी आने लग गया. But that is because instinctively we have a greater confidence in my understanding of justice than to be forced to follow somebody else who blindly said it.
Right.
This is who we are as a people. Culturally, we like the idea of delivering justice. That is why we sidestep or we avoid an inconvenient judgment. And this happens only at the superior court. See, at the district court, etc., they have no flexibility to do these tricks. So, वो बेचारे फंस जाते हैं. But most of our justice is delivered at the lower court level. Not at the high court, Supreme Court level. The other thing that happens is what is called, I distinguish a case on facts. Yeah, I'll say, नहीं वो facts में ये थोड़ा अलग था. उस दिन धुआं था आकाश में, इस दिन आज आकाश में धुआं नहीं है. तो I'll take some reason to say कि उसमें facts अलग थे and I come up with something else. Now, again, it presents from a legal theory perspective conflicting decisions. And that makes the law unpredictable.
Right.
So, one is this whole precedent thing is because there's so much pressure from our society and our basic instinctive way of looking at things that we don't like our hands to be tied by precedent. That is instinctively who we are, unless we are lazy. If we are intellectually lazy, it's the very convenient thing to do कि पहले उसने बोला मैं वही कर लूँगा.
Right.
But anybody who's a serious person and wants to do the right thing feels very constrained by the system. And we don't accept this readily. Now, this is the common understanding of the difference between common law and civil law. Civil law में क्या है? तुमने वो decision लिया होगा, लेकिन मुझे लगता है कि justice ऐसा है. Even if it has happened in that case, that is not binding on me. I can choose to follow that earlier case or I can choose to take my own path. Now, there is greater predictability in that sense because अगर कोई वकील उस situation में advise कर रहा है, he can say कि हाँ एक पुराना केस ये था लेकिन मुझे लगता है कि तुम्हारे facts में ऐसा होगा. So, the predictability actually improves. Today, the predictability is gone for a toss because let's say पुराना केस ये है तो ऐसे ही होगा. Suddenly, I find something else is happening.
तो आपको एक जज को फ्रीडम नहीं मिलता कि वो
In theory, freedom नहीं मिलता, but वो जज चालूपना करके वो he delivers justice. But that justice is different from what the lawyer had predicted, which is based on precedent. So predictability of the law becomes a casualty.
Right.
Now, this is the way most people understand common law and civil law. I got into this because I just wanted to sort of make the distinction ki how people understand it. But this is not really the reason why I say you must make the change. I say that you must make the change for two completely different reasons that are not part of our public discourse. The two reasons are the following. Is that जब आप कोर्ट जाते हो, according to you, जज का काम क्या है?
जस्टिस देना, फैसला सुनाना.
जस्टिस देना का. कॉमन लॉ में जज का काम है ऑफ एन अंपायर. वो देखेगा कि एक साइड ने क्या बोला है, दूसरे साइड ने क्या बोला है, and he has to pick one of the two. There is some degree of flexibility to go beyond that, but it is very rare that Indian judges use any of that. Mostly, common law principle is that you will basically pick one of the, you are an umpire. You are under no obligation to determine the truth. You have no obligation to deliver justice which is different from what is being argued. So you have to pick one of the guys. So actually uska काम is to pick कि कौन ज़्यादा reasonable sound कर रहा है, who is sounding more logical, which also gives a huge primacy to the lawyer. According to me, judge का काम should be principally to deliver justice. ये लोग जो भी बोल रहे हो, I should have the ability to inquire beyond.
Right.
It should be my obligation in law to find the truth and deliver justice. Today, justice in a common law system is redefined to mean who do I think is the better presenter of his case, his or her case. So that is one, is that in the end, people say, नहीं इसमें तो mayhem हो जाएगा. अरे कौन सा mayhem? यूरोप में कौन सा mayhem है? जापान में कौन सा mayhem है? तुमको लगता है कि वहाँ कानून नहीं चल रहा है?
Right.
So it is, how do you determine the truth? How do you go beyond what somebody may not have enunciated? Because you believe that your obligation is to find the truth. So that is one element. The other element is in the context of criminal law. हमारे यहाँ system, again following the US, I mean the English and therefore the US system, is that पूरा burden of proving the case is on the prosecution.
Right.
Defendant को कुछ करने की जरूरत नहीं है, जो prosecution बोल रहा है उसमें छेद करते रहो. And अगर आपने sufficient छेद कर दिए तो judge uncertain हो जाएगा. Judge will say कि though I believe this guy is guilty, I have no option but to acquit him. So that it ties into what I was saying earlier. That is what happens in the common law system. So there is a right to remain silent. It's an absolute right. A judge may take inferences out of it, but in the civil law system, I am actually supposed to give some explanation. कि मैं वहां नहीं था, ये नहीं था. I can't only rely on puncturing holes in the prosecution case. So it's a more balanced system. कि अगर somebody has been arrested as an accused, he has to also say कि why I am not guilty. He can't say कि my only job is to find holes in your case. So it's a more even system. You look at what is that are people, again I go back to what is people's sentiment.
Right.
By and large, and there is no statistics available on that, and nobody's done surveys on things like this. But I will say that a common Indian person, which includes you and me, wants the judge to meet their determination. If fact kya hai, truth kya hai, and I want the accused to make out his defense.
Right.
He can't just puncture holes in the prosecution case and get out. तो तुम बताओ कि तुमने क्यों नहीं किया, तुम भी बताओ कि अच्छा तुम यहाँ नहीं थे, तुम कहाँ थे. You also prove कि मैं एक्चुअली वहां पे था.
तो बर्डन एक पार्टी पे ही नहीं होना चाहिए,
सिर्फ प्रोसिक्यूशन में नहीं होता.
प्रोसिक्यूशन पे नहीं होना चाहिए.
क्योंकि आप ये भी देखो ना, हमारा प्रोसिक्यूशन सिस्टम भी कितना कमजोर है.
राइट.
फ्रॉम द इन्वेस्टिगेशन ऑनवर्ड्स की पुलिस को कॉम्प्रोमाइज कर दिया, देन प्रोसिक्यूटर को उसमें से एक भी अगर कड़ी वीक हो जाती है तो केस गिर जाता है, तो आपका क्रिमिनल छूट के चला जाता है.
बहुत से केसेस आते हैं एक्विटल हो जाते हैं क्योंकि वो प्रूव ही नहीं कर पाते.
उसके बाद वो लोग आना से घूमते रहते हैं कि मैं तो
छूट गया,
मैं तो इनोसेंट था. तो so that is not what, if you look at public sentiment, that is not how we see the law. That is not what we want of our law. We want our law to be more functional.
Right.
We want it to be more, we want our law to take the bull by the horns. Right. It can't be a passive spectator.
Correct.
It can't be an umpire. We are not interested in umpire. We are interested in a Sehwag.
Correct.
और विराट कोहली.
रूल सेट है क्रिकेट के, उनके हिसाब से ही बोला.
हमें वहाँ मतलब I don't name any other cricketers, but the other cricketers धीरे धीरे बैटिंग करते हैं, हमको बोल नहीं चाहिए.
True.
So that is who we are, and that's why I say that we should seriously consider this move, because internally a sentiment is building up. It's not only the panwala that wants it. The judges who are behaving in the manner that I am saying, that they want to, that they are sort of circumventing case law, are also behaving in the same manner. That is who we are as a people. That is what we want.
Correct.
We should not allow this colonial legacy to constrain us, to tie us down. And also because we neither have the courage nor do we have the imagination to get out of it.
Right. But so I have two last questions. So there are certain issues जहाँ पे society बहुत divided है. Some say it should happen. So one is legalizing prostitution. And there are both pros and cons, just like anything else. What do you think as a legal practitioner? Should India legalize prostitution, and what are the pros and cons for this?
See, I'll come at it from two basic elements. And this is the third, the 2.5. One is the entire legal theory that a woman should have primacy over what she does, her decision making. It is her right to decide what she wants to do. With her body, with her mind, with whatever. It is not anybody else's right to say कि तुमको ये नहीं करना चाहिए, तुमको वो नहीं करना चाहिए, things like that. So it is her free will. When I suggest liberalizing prostitution, I also suggest extreme stringent state action on flesh trade. तुम जोर जबरदस्ती किसी को कुछ करा रहे हो, you have to go down on it brutally. And I use the word brutally, I mean brutal. I don't mean civilized action against people like that. I mean brutal action against people like that. Now you allow for a woman to take those decisions that she wants to. Some will say कि वो तो already allowed है, हमारे यहाँ कौन सा legal है. But practice law is कि prostitution is illegal. हमारे यहाँ कोई sentiment नहीं है
Right.
pro prostitution. That's half the point that I was making. The two big points that I was making was when I look at what are the consequences of prostitution. So I actually stepped away from being a commercial lawyer for a couple of years in 2017. I tried to do grassroots politics.
Okay.
I tried to set up what is called a classical liberal party, which means individual liberty oriented and free market oriented.
Right.
2 साल मैंने यहाँ धक्के खाए, कुछ भी नहीं हुआ. Then I realized कि मेरे बस की बात नहीं है. देश को ऐसा एक सेंटिमेंट चाहिए, लेकिन मैं उसमें नहीं फिट होता. So I came back to the practice of law. But in those 2 years, one of my party's agendas was liberalized prostitution.
Okay.
And I took this conversation across cities and into villages and rural areas.
Okay.
My experience has been 90 to 95% of men were opposed to the idea. कि क्या बात बदतमीजी टाइप का बात कर रहे हो आप. I am yet to encounter the first woman that opposes the idea. Not an urban woman, not a rural woman. For a woman, it's a non-issue. So here, I am now beginning to imagine, is this a patriarchal idea कि I need to protect my women?
Right.
भाई अगर तुम जाके prostitute के services avail नहीं करोगे तो the profession is not needed.
Right.
तो तुम, you are very happy. 90-95% people are opposed to it. तुम publicly उसको opposed to हो. But तुमको वैसे action चाहिए.
Privately you
want action. The women it's a non-issue for women. Because they completely understand this whole agency element, that I have agency. It is my body, it is my agency. You are nobody to dictate to me. So that is one element of just the truth. That was a new dawn of truth for me. I initially came at it from the perspective of women's safety generally. So when you think in terms of women's safety, very often the thinking is, look at the number of rapes that are happening.
Yeah.
Now, in my own head, I think of a rapist as a sick person. There's something wrong in the head. Some psychological issue. And it's not as if every second woman is getting raped in the city.
Right.
But I can assure you one thing. Every single woman in the city has been sexually harassed. She goes out to the market, she gets harassed.
Right.
Somebody looks at her in one way, somebody tries to touch her and brush past her, or there is non-stop sexual harassment. There is not a single woman in Delhi who can claim that I have not been sexually harassed.
Right.
And it doesn't mean that only at a low level of society you get harassed. You get harassed at all levels.
Very true.
Now the question is, what drives that harassment? It's common people. It's people like you and me that end up doing that harassment. We don't think ourselves as criminals, but you end up passing a lewd remark. You end up scaring at somebody in one particular manner. If somebody is too close to you, you get a bit excited. This essentially, if you look back at it, is driven by the fact that sex is not freely available for us. It's not professionally available, it's not freely available.
Right.
So what you have done is because you have taken this Victorian idea that sex should only be within the confines of marriage. Because the whole Christian idea is thou shalt not commit adultery. This is not a Hindu concept. This is an Semitic concept.
Yes.
That thou shalt not commit adultery, thou shalt not covet your neighbor's wife.
Right.
These are very, very 10 commandment type of ideas. Again, I'm not critical of those ideas. I'm saying that we need to recognize that these are not inherently our ideas.
Yes.
You look at any of our gods and look at their behaviors. They have more than one. Except for Ram, everybody has many wives.
Yes.
You look at Krishna.
And everyone is. Very true. Right.
So you look at, traditionally, we have not looked at physical intimacy in the manner, in that sort of negative fashion that the colonial thought process has brought to us. Our women were dressed differently. Are we aware that petticoats and blouses are Victorian clothing? Our women did not. I mean, my grandmother, she's the landlord's wife. She did not wear a blouse on many occasions. I used to feel embarrassed that she didn't, But she was sort of culturally, that was, she'd wrap her sari around her.
That was acceptable.
And for many people, it continues to be the case. And for many of us, 2 generations back, that was common practice. So I then looked at what is causing this sort of behavior from many of us who are proper, decent, regular guys. But we end up with this lewd behavior.
Right.
Then I think of my daughters, will they also have to face the same? And I think that the reason why this is happening for the normal guys, these are not the psychos, but these are normal guys that are behaving like this, is because you have, on the basis of some Victorian ideas, built a society of deep sexual frustration.
Right.
And that is what is causing this sort of bad behavior, this bad spillage. It is no longer the case, but 20 years back, it used to be the case that Bombay was a safer city than Delhi for women. Why was it so? Because in Delhi, prostitution was difficult to get. Bombay, it was easy to get. You could very easily go and relieve yourself and come out and everything would be hunky-dory. Bombay had a lot of immigrant labor, more than Delhi did.
Yeah.
But women were still safe. They could alone go in 2 o'clock in the night. Aaj ke din pata nahi kya, aaj ke, I don't think it holds good anymore. But Delhi was always considered unsafe because in Delhi it was always taboo and strictly prohibited.
Right.
The cops would come down on you every time. In Bombay, they would not come down on you.
Right.
So those are the sort of drivers that got me to thinking that one way to sort of, rapes will happen when they have to happen and you have to deal with them the way they have to. But at least get rid of this daily harassment that women face. And the one way to do it is to actually allow, with less taboo, availability of sex. So therefore you legalize prostitution. It also came to me when this Bhaiya thing had happened. Lots of foreign women were scared of coming to India.
Right.
So these are clients. And one particular Chinese lady actually asked me, she had a detailed conversation, should I come to India? Is it safe? I said, look, that's one case and rapes are happening all over the world. I mean, look at the US, etc. You don't ask this question when you go to the US.
Right.
Why you ask it? No, there's so much of media frenzy. Then she asked me this question. She said, in India, do you have legalized prostitution? And I said, no. In fact, we don't like it. We come down hard on it.
Yeah.
And she said, so that is what is the problem. Is that she said, even in China, it's not as if it is legal. I mean, we all go to Singapore and we say Singapore is a very safe city. There's legalized prostitution in Singapore. Where there is legalization, this daily harassment that women face goes down. It will not be eliminated, but it will go down.
Right.
And that is what my target is. So there are multiple issues that go to sort of lean in this, but it is giving agency back to women. It is for the woman to determine. It is not for a men
to decide what.
Men-controlled parliament to determine whether prostitution should be legal or not.
So last question is again the contentious one related to freedom of expression. We have seen people talking of, that freedom has been curtailed by the government. Yet the question is, who determines and what falls under its purview? So if a student in JNU shouts, Bharat tere tukde honge, if someone, when we have a law passed in the parliament which says that Jammu and Kashmir, the full Jammu and Kashmir land is a part of India, a constitution says so, and yet people say that Jammu Kashmir was never part of India, and I say this as an Indian, and it's the Indian government's fault. I'm using my freedom of expression. How and where do you define what is freedom of expression? What is included, what is not included?
Let me first go to freedom of expression as a separate from this Bharat tere tukde honge sort of thing. Let's talk about what is freedom of expression. So what is freedom? You have to ask yourself, is freedom the right that I allow others to do what I like or what is acceptable to me? Or is to what is acceptable to you, तो तुमको freedom देने की जरूरत ही नहीं है. वो तो तुम भी खुश हो, वो भी खुश है. So there is no need for a concept of freedom.
Right.
So freedom becomes a concept when, in its very essence, is a concept that comes in the context of you have the ability to do things that I do not like or I dislike.
Right.
And you are still entitled to do it without me taking any adverse action against you. That is basically how I look at freedom. Remember, I said that I'm classical liberal, so I'm sort of very freedom oriented.
Right.
Now, the boundary of that freedom doesn't in my head and in law does not stop at where you are sensitive to मेरे को अच्छा नहीं लग रहा, it is hurting my sentiment, etc. You have to be clearly illegal. Now, some of the laws are written in a manner where you can say that this hurt my sentiment, so it is illegal. So those are things that need some fixing. Because I can also say that the fact that you're breathing is also inconvenient to me.
Right.
So, I mean, same, the entire caste system functions on that basis. कि वो मेरा जो अछूत है वो तो मेरे नजर में भी नहीं आना चाहिए.
Yeah.
So, what is offensive to you can be, anything can be offensive to you.
Correct.
The question is, that is not the dip test for figuring out has that person's freedom stopped over there. So, the dip test is really whether something is illegal in the sense, is it bordering on criminality? And as I said, we need to fix some of those things that also the way the laws have changed and have been interpreted in terms of what is criminality or not. Now, let's take a look at Bharat Tere Tukde Honge. So, I dislike the idea of anybody saying Bharat Tere Tukde Honge. I dislike it intensely.
Right.
But I dislike many things in many people.
Right.
Does it mean that I should now be entitled to go and hammer the living daylights out of them? Let's say I'm a vegetarian. मेरे को अच्छा नहीं लगता कि कोई नॉनवेज खाना खा रहा है, मेरे को स्मेल आ रही है, तो मैं उसको जाके धो दूं. Similarly, alcoholism, cigarette. I mean, बाकी तो तुमको तब भी नहीं आएगा. Cigarette is damn irritating for somebody who is not a smoker. So then I should say it is damn offensive and it should be banned in the country. This is the context in which I'll look at Bharat Tere Tukde Honge. 4 dysfunctional chaps who have got no jobs, who probably have no hope of getting a job. I don't know what their circumstances. I'm not on top of really that particular fact situation. But if somebody wants to scream that my mother is like this and my mother is like that, I mean, feel free to, as long as you are not creating a law and order problem.
Right.
तुमने कोई इलीगैलिटी तोड़ फोड़ किया, तुमको वहीं पे धो देना चाहिए.
Right.
तुमने सिर्फ आवाजें की हैं, बैनर उठाया है, इन माई वर्ल्ड व्यू बैनर उठा के चलते रहो. यू वांट टू से भारत तेरे टुकड़े होंगे, एज लॉन्ग एज तुम 4 लोग जा रहे हो, तुम बोलते रहो. फॉर मी द ऑपोजिट ऑफ लव इज इंडिफरेंस. आई विल बी इंडिफरेंट. Now, if you create, if that 4 people, so this is not an absolute way of looking at it. If that 4 people now expands to 10,000.
Yeah.
And there are 10,000 guys who are saying, Bharat Tere Tukde Honge. Now, there is a greater danger because this is now likely to spill into, एक तो 10,000 लोग एक साथ gather होंगे तो it is inconvenient for many people.
Right.
जब तुम रोड पे घेराव हो गया तुमने, it is illegal for you to घेराव the road like that.
Right.
So, like I said, my dip test is illegality.
Right.
तुम 4 लोग फुटपाथ पे चल रहे हो और उसमें शोर कर रहे हो, करते रहो. As long as you're not causing criminal nuisance. But, शोर करते रहो. 10,000 लोग जमा हो गए तो you have started creating nuisance. That is, you have to sort of be hauled up.
Right.
The fear that 10,000 लोग अगर करेंगे या 4 लोग करेंगे, उसमें से एक टेररिस्ट बन जाएगा. जब वो टेररिस्ट बन जाएगा, उसको ठोक दो. In anticipation, don't melt out penalty. Otherwise, we'll go into, आपने वो पता नहीं कि हॉलीवुड मूवी देखिए माइनॉरिटी रिपोर्ट.
Yes.
क्राइम होने के पहले ही तुमने पकड़ के ठोक दिया उसको. So, don't get into that frame of mind. Prevent to the extent that you can. And if illegality happens, you immediately come down swiftly on illegality. So there has to be a balance. In the balance is restored when freedom is a romantic idea when it is also ring fenced by legality.
Right.
Freedom is not freedom to do the illegal.
Of course.
वरना तो मैं आपके घर में चोरी भी कर दूंगा, मैं कहूँगा फ्रीडम, मेरे को तो खाने का हक है. I have a right to life and livelihood. मेरे को कोई और जगह मिलनी नहीं, मैंने खाना चोरी कर लिया. So that's not freedom. So if 4 guys are shouting something, I'm not like it. मैं भी जाके उनको 4 गालियां दे के आ जाऊं. क्योंकि गालियां देने में कुछ, मैं भी उनको जाके तुम लोग बेवकूफ हो, गधे हो, ऐसे बोल के आ जाऊं. As long as that also does not cross the line on criminality.
Right.
So I also have the ability, if I dislike something intensely, I also have the ability to do things that are within the legal remit.
Right.
Then the question, that's as a private citizen, my reaction to it. The question is, should the state function in a manner that it comes down heavy on for people that you could have ignored,
Right.
that have not yet crossed the threshold on crime, even if they have the potential to cross the threshold on crime. This is again views on how a state must operate. My view is that until somebody crosses, merely because they have potential to do it, you don't act. You keep a very close watch on them. If they cross the line, hammer them down.
Right.
But if they don't, again, when I say hammer them down, it has to be proportionate to the
crimes.
to the crime.
Right.
It doesn't mean कि एक आदमी ने चोरी किया तो तुम उसका हाथ काट दिया. That is not India, then that's some other country. कि तुमने चोरी के लिए हाथ काट दिया. So, how do you deal with it as a state in a proportionate manner? How do you then, when you deal with things in a proportionate manner, it feels just, and you do not create new opposition to just because of there is excessive state action. See, one of the things that you remember is that excessive state action also creates a reaction.
Yes, of course.
So how do you sort of, अगर कोई innocent आदमी को तुमने पकड़ के धो दिया, तो you will get angry. मतलब अगर तुम्हारे घर में से भाई बहन किसी को कॉप्स उठा के ले गए, तो उसको कुछ लेना देना नहीं. You know that person is innocent, or at least you know that इन्होंने कुछ किया भी होगा तो उस proportion में नहीं है जितना state action ले रही है. तो तुम नाराज हो जाओगे.
Right.
अच्छा, अगर तुम्हारे में हिम्मत है तो तुम भी illegal हो जाओगे. So that question is, how do you want to govern?
Right.
Do you think that you will be, and I'm not in position of government, so I don't have to sort of give an, I'm just doing a conversation around this. How do you want to govern? Do you want to govern with a heavy hand? That is a choice that you make. You bear the karma of heavy hand.
Yes.
If you want to govern with light hand, are you too weak in your governance? Again, you bear the karma of that. Whether you do it with heavy hand or light hand, your karmic consequences will also be borne by me as somebody who has not participated in the decision.
Exactly.
So be mindful of these outcomes, and then you do what you have to do. So it is not something that if I was in state, that I might do. Somebody else does it. I may not be in agreement with it. In certain other situations, I may be in agreement with it.
Right.
So coming specifically to the JNU situation, I, for example, would say, as state, I may require my supporters to also go and raise slogans.
Right. Of course.
To counter slogans. Slogans counter with slogans. You counter louder slogans. You do things to ridicule somebody who is making those slogans.
Right.
There are many ways to deal with it. Heavy-handed is not essentially the way I would go. But if it then accumulates to, like we have seen, larger protests that start creating public inconveniences, I think the state must act.
Wonderful. I think this was some really great food for thought. And thank you so much, sir, for your time. I think I learned a lot about law from this session and, of course, their book. So all those who are watching, this is one book I strongly recommend. It's not about whether you want to know about law or not. If you care about India and its future, I think this is one book you must be reading. Mr. Prasad, thank you so much for your time for Kitabi Baat.
Thank you, Abhishek, for this conversation.
Thank you.